Welcome to the webinar, How do you specify terms of use for research data using licenses? I am copyright attorney Maria Rebinder from Aalto University, Copyright Advisory Services provided by the Research and Innovation Services of Aalto University. In the digital world, interoperability and standards are essential when we want to use research data. This interoperability means both technical and legal interoperability. Legal interoperability is achieved by using standard licenses when you define rights for the use of research data. Creative Commons licenses, and especially the CC BY license, are licenses that have become commonly used licenses when publishing and opening research data. Also the CC0 waiver has been used in many cases. Open Science and Research Initiative of the Ministry of Education in Finland recommends their use, and we'll come back to that also later. Why do we need licenses? Can't we just look up from the copyright law how research data can be used? Well, first of all, research data is protected in actually 4 different ways, depending on circumstances and nature of the research data. And copyright law doesn't allow wide use for research, which is needed when we want to have optimal reuse of research data. So licenses are needed. The Copyright Act protects works that are original, and so database, if it's original enough, can get copyright protection. Then there is Nordic protection of catalogs, which is also described in Copyright Act. And then there is the European sui generis protection of databases. And even ownership of data is different in different situations. Copyright to datasets is owned by researchers as natural persons by law when they do independent research, or the database right is created to researchers who do independent research. And university, the right are created to university when the work is not done independently. If you are following orders as a research assistant to gather copyright protected research data, then the university is the owner. Then Nordic protection of catalogs is owned again by the investor, the university, and sui generis database protection is also owned by the investor, university. Research data comes in different, there are different types of research data. There is raw data and analyzed data with an independent information value. The sui generis database protection doesn't generally protect raw data. For example, data that's collected through satellites or meteorological observation would not be getting sui generis protection because they represent things that exist in nature. But the catalog protection, Nordic catalog protection, just requires a large number of information compiled into a list table or equivalent. Therefore, the catalog protection also protects raw data, and that we have in the Nordic countries. So there is data can be protected even the raw data, by the catalog protection. Then there is the copyright protection for the databases, data sets, where there has been originality in the compilation of the data sets. There is reproduction right is very wide for copyright. So generally the right holder's permission has to be obtained for reproducing copyright protected research data. Sui generis protection provides right to control the whole or a substantial part of a database. Substantial part, evaluated qualitatively, refers to the scale of the investment in the obtaining, verification, or presentation of the extraction. And this is independent from the quantity of related to the general contents of the protected database. So the scope of protection for the sui generis database right is very wide. Sui generis and the catalog protection subsist until 15 years have elapsed from the year in which the database was completed. But if there's substantial new investment, the database is updated with a substantial new investment, a new term of protection starts. And therefore, the protection for databases can go on indefinitely if the databases are updated. So a new term of 15 years can start. So there is strong protection in European Union for research data in the law. But exactly what kind of protection has to be determined case by case. And who is the owner has to be determined case by case. Is it copyright protected research data? Is it catalog right protected research data? Is it sui generis database? If it's copyright protected, has the research data been done in an independent situation or in a situation where research assistants were following tasks given to them? As research data sets, as research is a continuum, and the research data sets contain material created in different times and different circumstances. After collecting data for some time, and in many research projects, it's actually very unclear even who owns the data in most cases. So terms of use have to be decided with agreements or licenses in order to allow reuse. And when you define the rights with the clear, specified, internationally interoperable licenses, such as Creative Commons licenses, standard licenses, then you enable further use of research data. The law doesn't achieve that. Licenses need to be applied. Researchers, of course, also share data without actual contracts on the rights, and this can work in some situations as well, but it can also lead to confusion on how that can be done, especially when people change in research projects, people change employment. It's better to have a standard license attached to the research materials, and then sharing can happen much more effectively. So with the licenses, you remove barriers to the use of research data. Without the license, the protection by copyright law, catalog, sui generis copyright protection would be an obstacle for the use of data. Even if a researcher has gathered research data, for example, at one university, and switches to another employer in another country maybe, or in private employment, it is safer for the researcher himself that the data is in a data repository with a standard license. Then all the researchers involved in gathering the data can be sure that they can reuse the data also in the future. Creative Commons licenses are ready-made licenses. The new family of licenses is the 4.0 license, which is international license because it was created internationally. It takes account the European Union database directive and different database protections in other jurisdictions. Altogether, lawyers from 70 jurisdictions were involved in drafting and commenting this license family, including Finland. Aalto University is the affiliate organization of Creative Commons in Finland. Usually they are all universities in different countries, and Creative Commons licenses we created at Stanford University in United States. In Finland, I am the legal counsel that took part in commenting these licenses, and also a team where I was member together with Henri Tanskanen and Martin von Willebrandt and translator Liisa Laaksonen-Tammisto. We also translated these licenses into Finnish. And all the license texts are equally valid in every language. The licenses have legally binding terms. In CC BY, the term is attribution, so you have to attribute the source and the authors of the research data. Open Science and Research Initiative of the Ministry of Education recommends CC BY 4.0 license for research data, and also, for example, this webinar is licensed under the Creative Commons Attribution license, so you can use these materials just mentioned. Attribution, the source and author, that will be me for this material. The Creative Commons webpage has all the information you actually need to use them. The Creative Commons licenses are expressed in three different ways, sort of three different levels. The first level is just the logo and the name of the license and link to the license. There is already visual information. The attribution term is showed in the form of a person. If you choose this CC BY license, you are free to share, copy and redistribute the research data, and also build upon the research data for any purpose. And this allows also commercial use, which is very good, for example, in research done in cooperation with companies, TEKES projects, European Union Horizon 2020 projects, where also commercial uses are hoped to be achieved. Attribution term is binding, so if you don't attribute, if you don't give appropriate credit to the original authors, then you don't have a license. The terms don't apply. So the attribution term is binding, but it's the only term you have to follow. And you have to provide a link to the license so that everybody knows the exact license, and indicate if you made changes. This short text that you now see is the second level of the license. But the license is, there's the actual what I could call legalese or lawyer-readable form of the license, which contains specifically and very clearly all the terms of the license. So this is the short, so-called human-readable summary of the license, but it's linked to the actual license. So when you license this research data of yours, you are licensing with a very precise, clear, actual license that is published online, and it's in several languages, for example in Finnish and in Swedish. Creative Commons licenses copyright, catalog protection and database protection. The earlier licensing families, Creative Commons 3.0 and older, are not recommended because they don't take the European sui generis protection or Nordic catalog protection into account. Privacy rights and rights protecting personal data are not licensed with Creative Commons licenses. So if you license with Creative Commons licenses, you are not giving a permission to use personal data. I just added a few notes about personal data. If your research data contains personal data, you should anonymize it before publishing it as open data, preferably. And anonymizing means that it should not be reasonably likely recognized by third persons. So if it's reasonably likely that a natural person can be identified, then you should anonymize it in order to share it as open data. But this is just a note to take into consideration, but I stress that the Creative Commons licenses do not license privacy rights, such as right to use personal data. So it's just licensing the copyright. Then there is also the CCO waiver. It's widely used when opening databases as well. And CCO waiver doesn't have any of the terms of use. So you are not required to attribute the source and the authors as a prerequisite for the license to apply. So if you don't attribute material that is published with CC by license, then you don't have a license. But if you don't attribute material published with CCO, then you still can use it. And there can be big data uses, for example, gathering research data from 1,000 or more sources, where even that term attribution would cause complications. But usually, or in all cases when research data is released, or in most cases where research data is released with the CCO waiver, the owner of data asks the users to inform the authors of the research data and organizations in a certain way. So there's certain rules of the road. So if you use this data, please attribute according to the following, and then the researchers and affiliated organizations and how they want to be attributed, because in scientific connections it is always good scientific practice to name the source and the authors. And of course, is the data reliable? You can only ascertain that if you say the source, state the source and the authors. So even without the license term, users would be attributing the data. So CCO waiver is used. So it's a public domain dedication, CC0, and you dedicate the work to public domain by waiving the rights. And this CCO is also used when you publish metadata, the data describing the research data, because in metadata it is not customary to mention who wrote the metadata. It is facts describing the research data. And one thing to include in the metadata is the license, because the metadata tells you information about the research data, and the license determining how you can use the research data is very important for anyone who will use that data in the future. So that license should be mentioned in the data describing the research data. And if a researcher shows his research data, for example, in a conference or seminar, the license should be included, for example, in PowerPoint slides, like I have done with these PowerPoint slides. In the first page, I have the license included in them. Here's an example from the Zenodo data archive. When you look at research data that is published there, you see metadata or data describing the data. You see publication date, digital object identifier, community it's related to University of Turku, and the license, which is the Creative Commons Attribution license. So this data can be used to any research purpose, including commercial uses, but you have to cite the attribute the researchers who have produced this research data. And also Zenodo has automatically creates you the citation type that you want to use when you use the data. So using the data and taking care that you always attribute the original authors when you cite the data, that has been made very easy in the Zenodo archive. Here's another example from the Zenodo data archive. This is now published. Global Food System Resilience Indicators data is published using the CCO waiver. So also uses where the authors are not attributed are allowed, but naturally in a scientific context, if you use this data, you would tell the source and the authors of the data, the researchers, according to good academic practice. So even if the license terms don't force you to do it, then you still would give the authors and attribute the authors in any scientific use. The Creative Commons family also has other licenses. You can add the term non-commercial. If you don't want to allow commercial uses, you can have the non-commercial term added. If you don't want to have the possibility of others adding to your research data or using your research data as part of a larger data set, you could use the no derivatives. And if you want that everybody will share with the same terms, you can also choose the share-alike additional terms. So there are different license features can be chosen to restrict the use, but according to the open science philosophy, restrictions often take away from the optimal reuse of research data. So the attribution term is recommended, and further restrictions such as non-commercial, no derivatives, share-alike, they are generally not recommended, but in some situations they can be good. For example, if you want to allow open use for non-commercial uses and then keep the opportunity of commercial licensing as an option, you can double license, first license with the non-commercial license and then license to, for example, companies with a separate commercial license. So it's easy, you would just add the license information to your materials, copy the logo, the link, the name of the work, and the authors. And instructions on how to add the license to your materials are in the Creative Commons webpage, and you don't have to register, you don't need a permission to use it, you just add the license and start using it. So here is some of the basic things about using the Creative Commons licenses to research data. Are there any questions today? Okay. Do we still have more time, or I don't see the time now?
Yeah.
Okay. If there are no questions at this point, then you can send questions to me at my first name, last name, Maria Revinder at aalto.fi if you come up with related questions later. Thank you for following the webinar.